Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. The California Appellate Law Podcast is a resource for trial and appellate attorneys. Both Jeff and I are certified appellate specialists and uncertified podcast co-hosts. We try to bring our audience of trial and appellate attorneys some legal news they can use in their practice. If you find this podcast helpful, please refer it to a colleague. If you don't find it helpful, please refer it to opposing counsel.
Yeah, and a quick announcement and thank you to our sponsor, Casetext. We're sponsored by Casetext, and it's a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a Casetext subscriber since 2019, and I highly endorse their service. Listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP. And be sure to check out Casetext's new product, CoCounsel, an interesting AI product they are rolling out in beta.
It's a very exciting product. Excited to try it out. All right, Jeff, so continuing on our project to compare civil procedure rules in California to those in other jurisdictions, today we're privileged to welcome John Nielsen to the show. John Nielsen is one of the most experienced appellate attorneys in Utah, having litigated over 100 appeals and argued more than 70. Prior to starting his private practice with Lee Nielsen, John served 11 years as an assistant solicitor general for the state of Utah, representing Utah in criminal cases in the state trial and appellate courts. He also litigated in federal court, defending convictions in habeas corpus proceedings. During his time as an assistant solicitor general, he also served as a Supreme Court fellow for the National Association of Attorneys General in Washington, D.C., and authored or co-authored 6 state amicus briefs in the United States Supreme Court. He serves on the Utah Supreme Court Advisory Committee for the Rules of Evidence and currently chairs the Appellate Representation Committee. John also regularly publishes at the Appellate Advocacy Blog, part of the Law Professor Blogs Network, writing on legal writing. So, John, welcome to the podcast.
Thank you, Tim. It's great to be here. Thank you.
Well, appreciate your being here. Appreciate your participating in this project for us to learn about the rules of civil procedure in other jurisdictions and how they compare. Jeff and I sometimes grouse, or maybe I spend most of the time grousing about some of our appellate procedural rules and civil procedural rules. But it occurred to me maybe we're on par with other jurisdictions. Maybe we're even ahead of the curve at other jurisdictions, and maybe there's things we can learn from other jurisdictions. So I'm anxious to know how Utah handles some of the issues that we talk about on this podcast on a regular basis. But first, let's learn a little bit more about you and your practice. Can you tell us a little bit about your primary practice area these days? What are you doing on a daily basis?
Sure. So I say we, me and my partner Tom Lee just stepped down from the Utah Supreme Court last summer at the end of June. So we launched this firm in July of last year. And our practice, like a lot of appellate boutiques, encompasses both direct appellate practice, like doing appeals, briefs, oral arguments, that sort of thing, as well as working with trial counsel, either as co-counsel or sometimes just as counsel, to work on dispositive motions, to help with legal issues, to help ensure that issues are preserved for appeal, that sort of thing. At any given time, the percentage of those is going to wax and wane a little bit, but that's kind of the mix of practice: general civil litigation with an eye toward appeal, as well as the direct appeals.
Yeah, do you find yourself in that? There's a term that was coined. I don't know if it was coined by Corey Webster. We had Corey Webster on the podcast a while ago.
Yeah, I know Corey. He's great.
Yeah, embedded appellate counsel. It's when appellate counsel is kicking around, rubbing elbows with the trial attorneys in the trial court. He or she is still an appellate attorney, but they're embedded in the trial team. Do you do any of that kind of embedded appellate counsel work?
Yes, that's a good way to put it. Yes, yeah. We've done several things like that.
Yeah, I like to say that I don't want to tell the trial attorney what they should have done. I want to help them do it in the first place. All right, John, tell us, do you prefer being in state court in Utah or in federal court?
I've practiced mostly in state court, and I'm very comfortable there. But there's something about practicing in federal court. Maybe it's just because we have a really nice, newer federal courthouse here in town. But just walking in there, I had a hearing in federal district court about a month ago, and I hadn't been there for a little while. and it just felt much more lawyerly to go into federal court than it did state court. I don't know if that makes much sense. I enjoy the practice in both, of course, but there's something about federal court that just feels a little more important.
Intimidating.
Yeah, and sometimes intimidating too, right? It could be that the judge presiding at the hearing was my former law professor, so maybe that added an air of dignity that otherwise would have been lacking. But
right. To foreshadow our discussion about comparisons in civil rules and appellate rules of procedure, have you encountered any major differences in your state rules of procedure versus the 10th Circuit rules of procedure in either trial or appellate proceedings? Something that maybe caught you off guard one time when if maybe the first time you were practicing in the 10th Circuit and you realize, oh, this is different. I remember once as an early practitioner, having done a couple of state appeals here in California, when you miss your deadline to file an opening brief, they have this very congenial system where they send you a 15-day notice of default saying, here's your automatic 15-day extension, basically. And as a young associate, I got used to those in a couple of appeals. And then I had a Ninth Circuit appeal with the deadline looming. And I thought, oh, no problem, I have a 15-day extension. And then I sat up, bolt upright in a cold sweat in the middle of the night. And I thought, this is a different jurisdiction. That rule probably doesn't apply here. And it turns out it does not. So the next day I was drafting my motion for an extension.
Yeah, good on you for paying attention to that feeling, because those kinds of procedural rules are always a big trap for the unwary, right? I don't think it's a difference so much in the substance of the rules. I think the rules themselves are quite similar, but I've noticed in federal court, in the 10th Circuit, for example, that enforcement of procedural rules is much more strict. If you don't comply with, everybody's strict with like notice of appeal deadlines, that's jurisdictional. But if it's something like a briefing rule, or it seems to be a function of how busy the courts are. The busier a court are, the busier a court is, the more likely that court is, I think, to strictly enforce procedural kinds of rules, like not bypass procedural arguments just to get to the merits. They will dispose of more things on those kinds of, non-lawyers would say, technical grounds than they might in a less busy state court. So that's one difference I've seen.
Yeah,
the strict enforcement of those kinds of procedural rules.
That's right. They have, the privilege of seizing on those technicalities. John, do you prefer being the appellant or the respondent on appeal, or do you call the respondent the appellee in your Utah appellate system?
We have both titles in our system. It depends on which court you're in. So if you're doing an appeal as of right, you're going to be the appellant, and the other side will be the appellee. If you're there on writ review, or whether it's cert or extraordinary, then it's petitioner and respondent.
Okay.
So
who do you like to be, the challenger or the defender?
Oh, I think anybody would prefer to be the defender, because it increases their odds of prevailing so astronomically.
That's right.
So it depends on what you like. I mean, sometimes it's fun to kind of charge up the hill and take on the lost cause, as it were. But all else being equal, I would prefer to be in a position of strength than not to.
Yeah, and before I ask you to share a good war story, that if you have one, let me ask you if there's something about the way you practice that you think your clients or opposing counsel would say is unique about you.
I think I have a reputation, whether this is good or not is open for debate, I suppose, for being a little bit more colloquial than most. Appellate attorneys, especially very prominent appellate attorneys, tend to have a reputation for being a little bit more formal, a little bit more restrained, that sort of thing. But my style in briefs and in argument tends to be a little bit more probably conversational than a lot of people might think. I have cited to all sorts of things in my briefs, from video games and Urban Dictionary to other kind of non-traditional sources. Now, I always do it for a purpose. I'm not just doing it to show off. And I could could explain my reasons if anybody would care to hear them. But I have that little bit of playfulness, I guess, to my advocacy that perhaps surprises some people, but is consistent with my personality, I guess.
Yeah, I like that. I think there is a trend in legal writing toward the more colloquial, the more informal. So I think you're swimming with the tide on that one.
How do you find the time to do appellate work when you live in a state with canyon lands and Arches National Park? If I lived in your state, I would be hiking and biking those trails constantly.
I am a huge hiker. What really keeps me from hiking as much as I would like, and I don't mean this to say they're an obstacle, but I have young kids, and having young kids puts a damper on outdoor activities more than any sort of work demands. But for what it's worth, I'm in St. George right now. That's the town that's closest to Zion National Park, and we definitely plan on taking advantage of the outdoors where it's not 30 degrees and covered in a foot of snow like Salt Lake right now.
Yeah, Tim, permit this one last segue. When I had young kids, I got them into hiking through a hobby called geocaching. Where I got my kids to go look for geocaches. I said, "Oh, there's 2 more up ahead," and that was the hook to get them into hiking.
Oh yes, we're definitely down here to expose our kids a little bit more to hiking. So here's hoping it goes well. I love the outdoors. That's part of the reason I'm from Utah, but I love getting out whenever I can.
Sorry. Okay. One more question by way of biographical. Can you tell us share a good war story or just a favorite appellate tip that you like to give to trial attorneys?
I think the best thing a trial attorney can do to understand appeals is to realize the kinds of people who are making the decisions. I think one of the most uncomfortable things for me is when I see a trial attorney come up and practice in an appellate court and treat the appellate panel as if they were a jury. And you have to know your audience, right? You have to understand who you're talking to. And the way that I often explain it to my legal writing students or to attorneys who are getting ready to argue in the appellate courts for the first time, who are used to trial practice, is, look, you have to remember who you are in front of here. You are in front of a panel of nerds. These are the kids in law school who, generally speaking, did extraordinarily well, were very detail oriented, cared about things like adhering strictly to Blue Book rules, because they use those as markers of credibility and carefulness. So when you're speaking to them, they're not going to want you to get up there and talk about the facts. They're going to want you to get up there and talk about the law. Now, there are some cases, every rule has an exception, right? It's like some appeals really do turn on the facts, and you have to really hammer that sometimes. But for the most part, they want to have a conversation about the law, and they want you to be helpful to them. So get up there and answer their questions, and answer them as succinctly and correctly as you can, instead of pretending that you're there to talk about what you want to talk about.
Okay, well, let's talk about your writing on legal writing. Now, you publish a blog, or you're one of the contributors to the Appellate Advocacy Blog. We'll post a link to that in the show notes so our listeners can find it. Tell us about why you do that. What are you writing about when you write about legal writing, and why do you do it? Who do you do it for?
Sure. So a little backstory first. When I went to law school, I knew no attorneys. I didn't have anybody in my family that was an attorney. None of my friends' parents were attorneys. I think I heard about somebody at school whose dad was an attorney, but I didn't know them. Like I just had no contact with the legal world at all. The most I ever was exposed to a courtroom was in 4th grade. We took a field trip down to the courthouse and put on a little moot court, and maybe a traffic ticket or something like that. But I was just never had any contact with it. So I felt really lost when I got to law school. I felt like I just didn't know what the structure was. I didn't know how courts worked. I didn't really understand what attorneys did. And I was so fortunate to have some wonderful mentors, particularly at the Utah Attorney General's office, where I worked as a law clerk before I was later hired as an attorney. who took the time to answer all of my questions, even the ones that I saw as stupid or the things that I should know the answer to. They took a lot of time to mentor me. And as soon as I became an attorney, I thought, I want to pass that on. I've gotten so much help from these senior attorneys. I want to help law students as much as I can, especially if they feel the way I did, which is lost. So whenever I've taken a job, I've gone to my boss and asked to be put in charge of the law clerks. I want to hire them. I want to train them. I want to help them. I want to make their assignments. I want to give them as good of an experience as I possibly can while they're working with our office. So all of that is to say, I also started posting on the Appellate Advocacy Blog because I wanted to help out law students and young attorneys. And in a lot of ways, I'm trying to write the things that I wish I knew when I was at their stage. Things that I feel like I learned later than I should have, and I hope will be good tips for them as they're developing a voice in their legal writing, as they're trying to figure out how to litigate cases.
That's fantastic. I got to tell you, in my practice, I can tell when a opponent of mine has lacked good mentoring, that they didn't have somebody like you molding them at a young legal age in terms of how do you write a letter? How do you write a brief? How do you attack arguments without attacking people and that kind of thing? It's really commendable you took that on.
It's sadly common, and I think that's part of it too. I even had a couple of contemporaries, some friends who went in different directions than I did, and I would see the way they practice and think, yeah, this could have changed so much. Knowing who your mentors were, or who they should have been.
Yeah.
Hopefully, it's a small contribution to the quality of the profession too.
Yeah. You have any tips? You have any tips for other mentors? I mean, you talked about how you like to mentor younger attorneys. Maybe you can offer me a tip as someone who has tried to mentor other younger attorneys, and I try to cram way too much at one time. They ask me one simple question, and 10 minutes later, I find that I'm babbling on about something that has nothing to do with what they asked me. I feel that I do more harm than help. Do you have any tips for me?
What works for me to kind of rein myself in, because I will talk forever too. Especially about appellate nerdy details. Like a lot of appellate attorneys, I love to debate the use of dashes versus semicolons and the use of cleaned up and all that stuff. I know about your lightning round. I've got my answers ready.
There is no serious debate about cleaned up, right? I mean, cleaned up it's here to stay.
The record is clear on that, Jeff.
Yes,
we set the record on
it or something like it. Yeah. But that's just to say that to rein myself in, something that I did was set up a program. So when I was in charge of our law clerks, during the summer, I would do weekly trainings, and it'd be brown bag lunches basically. And I had prepared, over the years, I had like 20 trainings, and then I just kind of set a schedule of what we're going to talk about that week to hopefully kind of organize myself and rein in my otherwise kind of rambling advice. So having a schedule essentially, and then scheduling time for it, is something that helps me.
And so now, is that going to bring us full circle to the Appellate Advocacy Blog? You mentioned that's also a resource for young attorneys to get them up to speed on what types of writing practices they should adopt. There was one of your articles that I picked out a few weeks ago, and it was back in January, and it was about imitation. It was about how to become a great writer by imitating other great writers. So I think your premise is that basically when you start out writing, you might not have your voice yet, but maybe you can find your voice like other great writers who have found their voice by copying those they admired as closely as they could manage. And you cite the example of Robert Louis Stevenson, who said that when he read something he liked, he, quote, set himself to ape that quality, and that by doing so was the only way to learn to write. And you said that after a time of such creative imitation, the writer would one day find his own voice. I think that is a great bit of mentorship for young legal writers. So I think that's a service that you make that available for young attorneys.
Yeah, and for that post, I got the idea from a couple of places, but the primary place was a guy named Scott Newstock, who is a Shakespeare professor. I forget the school off the top of my head, but he wrote a book called How to Think Like Shakespeare, which deals with where he kind of talks about the elements of a medieval education. What kind of educational system produced William Shakespeare and allowed him to do those kinds of things. And one of the techniques that they would use during that era was this imitation. And it sounds, we live in a society that is so used to novel things. I think we're about in the same age band here, that we all remember during our childhoods, things were very different. Phones were different than they are now. Computers were different than they are now. Like, so much was so different. It was, the past is another country, and it was so, we've seen so much change during our lifetimes, and we're so used to it that in a lot of ways we get bored with something that exists for, more than just a few years. It's like, well, haven't they updated that? Isn't this out of beta yet? We're always looking for some new thing. And so I think the old ways kind of get a bad rap, and people think, well, I don't want to imitate, I want to do something new. It's like, well, the paradox is you can't really do something new. First of all, you're probably going to reinvent the wheel, because there's been a lot of people doing this thing for a very long time, and maybe they figured out something you didn't. But imitation is also a lot harder than you think it is when you set out, because you think, oh, I'll just copy what they did. It's like, well, it's one thing to copy exactly what somebody's done. It's another to take on their persona, as it were, and their voice, and try to say something as if they had said it. Like, try to write a political speech as if Winston Churchill were alive today and giving it, right? It's not so easy, but that kind of act can really mold your thinking. And like the Stevenson quote that you read there, can really help you find your voice. So I was thinking of a generation that is not likely to admire or aspire to do something like imitate somebody else, except as a form of mockery, but as a form of learning. It is, I think, almost an endless source of betterment.
Yeah. Yeah, just your comments about imitation reminded me one time I gave this speech to an environmental conference, and it was right after I had finished listening to a book on tape by Bill Bryson, the humorist. And it was written, I can't remember the name of the narrator, but it was just a great narrator who had a real folksy delivery. And I remember that when I gave my presentation, I don't think I intended to, but afterwards someone said, I love your delivery. It reminded me of E.B. White, just some homespun, folksy tale. I thought, oh, that's interesting. It's probably because I've been spending hours and hours listening to this folksy rendition of Bill Bryson.
Oh, well, and one of my other tips to law students is, if you want to improve your writing, your legal writing, stop reading so much legal writing. Go read good writing. Go read Shakespeare. Go read some classical literature. Read poetry. I think poets and appellate attorneys, if you'll forgive, pushing this maybe a little too far, I think in some respects they have the same job. They're supposed to take something that's really complicated and has a lot of facets to it and reduce it to its essence and deliver it in a memorable way. I don't think any briefs are going to win any Pulitzer Prizes or poetry awards, nor should they. But those same kind of techniques and that same kind of thinking, like you said, you almost absorb it by osmosis when you're just listening to or reading good stuff. It can't help but bleed into other areas of your thinking and writing. And if it's good, then those downstream effects will be good.
That's right. And then just to circle back to something you had mentioned about informality, specifically the informality in your own writing. What do you what advice do you give to young attorneys on whether they should adopt informality in their writing? Do you have to get to a certain comfort level and experience level before you can kind of fudge the rules a little bit? What is it? There's a saying about you have to master the rules before you can break them.
Exactly. No, I give that same advice. I say, for the first 3 years or so, don't do it. The odds are that you're going to do it clumsily, and at best, you're just going to maybe distract your reader a little bit. So I tell them there are a few different elements. One element is experience, and you have to kind of get your feet under you before you know when you can do that sort of thing. The other is to read the room. You have to know your audience. I didn't start using contractions in briefs until some members of our appellate judiciary did. And then I felt a little free. I'm like, oh, you can do that. That's a thing that we can do.
Nope.
And yeah, I get it.
That's the trouble with appellate.
Jeff, if you were on the panel, I wouldn't do it because I know there's a chance that I'm going to alienate you, right? Or at very least, I'm going to distract you and then I'm going to lose the ability to persuade you. So you have to know your audience. And if the judge, or if there's a chance that the judges you're appearing in front of will have the kind of reaction the Jeff just had, then by all means, don't risk it. It's not worth it. But if you know your panel well enough and they know you, then the other piece of advice I give them is do it on purpose. It's kind of like the passive voice. So many attorneys and law students use the passive voice as a matter of reflex because they think it sounds lawyerly, and they think they're supposed to write that way. So they're kind of unconsciously embodying this abstract idea of lawyerliness that they've crafted in their heads. Most of the time, the passive voice just saps energy and decreases the quality of legal writing. But sometimes it's helpful, and sometimes it's useful, and sometimes it's even necessary because you want to focus on the action more than you want to focus on the actor, for example. So I just tell my students, look, whatever you're going to do, if you're going to use a contraction, do it on purpose so that you can draw attention to a particular point. If you're going to use the passive voice, do it on purpose. If you're going to have if you're going to cite to a non-legal source, then do it probably in a footnote, and do it in a way that's germane to the topic. Don't just do it and be just because you can, because you're trying to show off or be cute, because that's not helpful to anybody. So it should have a purpose, I guess.
That's what Tim would refer to in an earlier podcast about looking for the little darlings or the cute things in your writing and cut it out. Hey, what is the most out of the box non-legal source you ever cited to in a brief?
Urban Dictionary probably goes right to the top. And the reason that I did, it was this gang shooting case. And a lot of the evidence, it was pre-trial. So they didn't have a trial. And usually when you have communications between gang members, you'll have an officer or another expert to kind of translate what they're saying to each other, because they use a lot of slang. They use a lot of terms that are, or they use terms in a different way, right? And I guess that's also slang. But anyway, you basically need a translator to say what they're talking about, because otherwise it won't really make sense. And that's particularly true, I think, when you're dealing with appellate courts who tend to be a little bit older, and they're certainly not going to be looking up Know Your Meme and Urban Dictionary all the time to see what the kids are talking about these days, right? And maybe, I'm sure some of them are, but anyway, Jeff, go ahead.
By the way, breaking news, when your kids become teenagers, you're going to need to access that same Urban Dictionary to understand what they're saying.
Yes, I have a 13-year-old, so I fully understand. And then perhaps that's why I was familiar with it.
Well, John,
oh, sorry.
Did you hear? I think you were probably involved in this discussion on LinkedIn about this word that's sneaked in under my radar that my daughter's saying now. I'm glad I got the tip from I think from you and Charisse and maybe Lindsay on LinkedIn. Sus. So because there was someone put up this great, I think it might have been Charisse. It was either Charisse Bukowski or Lindsay Lawton who wrote a post about the differences between suspect and suspicious, when to use one rather than the other. Suspicious is the mental state. Suspect is the quality of the target of the suspicion. Anyway, and if you want to avoid having to know about the distinction altogether, you just use the word that the kids are using today, sus. Hey, Mom, that looks sus to me.
Sus, cap, no cap, and extra. Oh my God, those terms. I'm sorry. Is this a California parenting blog?
Don't forget bussin'. Bussin' is very important.
Okay.
And to yeet. Yeet's getting older. No, I actually knew about the sus because my 13-year-old a couple of years ago really got into the game called Among Us, and that's where it came from.
Oh, I see.
They would say, oh, this person seems suspicious. They're probably the alien killer. That's
I didn't know
the
that.
etymology of that idiom, so you're welcome.
Right.
Okay.
We'll have to put a glossary in the show notes, Jeff.
Yeah, cite to Urban Dictionary. But so I felt the need to translate what these gang members were saying to each other because it wasn't a trial, it was a pre-trial posture. And the trial court understood what they were saying to each other, but I didn't think it was self-evident. I thought, well, I have to translate this for the appellate court. It's actually for our Supreme Court. And there's really no other authoritative source on what this kind of thing means than that. So I would say, I'd quote a text and I'd say, that is to say, this is what they were saying to each other. Then I just drop a footnote saying, here's what these words mean in this particular parlance. So again, I wouldn't make a habit of it. I didn't really aspire to do it, but I thought that really was the best source to get across the information that I wanted to get to the appellate court. So that probably qualifies.
Did opposing counsel or the court balk at it?
No,
so,
not at all.
So the citation to Urban Dictionary went over okay, huh?
Yeah, and I actually heard through a mutual friend that one of the justices found it educational. So,
oh, good.
Actually,
interesting. All right. Well, now with the preliminaries out of the way, let's get down to business. We wanted to talk about some differences in civil procedure between California, where this podcast hails from, and Utah, where John Nielsen hails from. So, John, I'm gonna just kind of run down our list of some civil procedure topics. I'll just state briefly the way it's done in California, and you tell me whether it's the same or different, better or worse in Utah. Okay, so let's start. I had heard this. I'd heard this recently about that California is among the minority of jurisdictions where rules of civil procedure are set by the legislature rather than the Supreme Court, the judiciary branch itself. So in California, we have the Code of Civil Procedure enacted by the legislature. We also have a judicial council that promulgates rules of court, but they are subsidiary gap fillers. They're not allowed to contradict the Code of Civil Procedure. How does it work in Utah, John?
It's almost the opposite. So there's always this wrangling in any given jurisdiction. You see it with the U.S. Supreme Court and their rules committees in Congress. You see it in different states, and it shakes out in different ways and at different times, particularly with privileges. A lot of legislatures like to pass statutory privileges, and courts kind of balk at those sometimes. But in 1994, we had an amendment to our state constitution that gave our Supreme Court, state Supreme Court, the power over all extraordinary writs and also over court rules. So they are the rule makers. They have a rulemaking hat. They have advisory committees, one of which I recently served on. You said in my intro, I guess I need to change that on the website. I recently finished my term on the advisory rules for the rules of evidence here in Utah. But basically, if they have a question about whether to amend a particular rule, they'll refer it to their rules committee. They'll debate it. They'll give a recommendation that will go out for public comment, and then it'll go up to the court. And anyway, so they are the rule makers. The legislature has retained the ability to amend those rules so long as they follow a particular parliamentary procedure, rather than having just a normal bill to, I suppose, to tell the courts this is what we're doing, to let them know that they're going to be potentially amending their rules. They have to pass a joint resolution that starts in the Senate, I believe, the state Senate, and it has to pass by a supermajority. That they have the power to amend the rules. Now, the courts and the legislature haven't had an appetite to decide by litigation whether or not amending includes making new rules. Our legislature has done that sometimes. It's kind of like the U.S. Constitution, I suppose. They met to amend the Articles of Confederation and then offered something slightly more than an amendment.
Right.
But that's how it works in Utah. Our courts are ultimately in charge. The legislature, there's a little bit of push and pull that way.
So the legislature can amend if it's by a supermajority?
Yes.
And so those amendments would just be amendments. They would be incorporated into is it a Code of Civil Procedure? What are the court rules called in Utah?
They're just court rules. So the rules of civil procedure, rules of criminal, rules of appellate, juvenile, what have you.
Okay. All right, interesting. And in your experience, does that work fairly well? Because the next topic we're going to get to is about court reporters, and one of the reasons why we have a little bit of a crisis here in California is because court reporters are required. They're required under the Code of Civil Procedure, and even though the Judicial Council back in the 90s tried to relax those rules and allow for an electronic recording system, the Court of Appeals said, the Judicial Council cannot override the statute, and the statute doesn't provide for electronic recording, so there's going to be no electronic recording. So if the judiciary had the control, we would have electronic recording systems in California. I wonder if you have any examples like that, or any basis to say that one way is better than the other.
The last time I saw a court reporter in court was on a death penalty case, probably 13 or 14 years ago, because at the time, a live recorder was required for death cases, or cases where death was on the table. But other than that, I don't think I've seen one in court forever. Like maybe stock in those little typewriters they use has gone way down in Utah. We just don't have them much anymore. We just have all electronic recording, and then when you order a transcript, you just send it to a court reporter who types up whatever they hear in the transcript.
Wow. Can I ask? I know it's a little far afield from appeals, but for depots, like depositions, do you have court reporters, or are those also electronically recorded?
I've seen deposition. Well, I've seen a number of depositions where they're just video recorded, and I don't think I saw any court reporters there. It doesn't mean that nobody ever uses them, but I think they're kind of the live court reporter is largely not around in Utah.
Tim,
for that article you're working on, you need to take some notes here.
That's right. I'm logging this as research time for that article. Have you ever heard any reports from court reporters or elsewhere that these recordings that are then passed along to the court reporter to prepare a transcript are degraded, are insufficient for whatever reason to provide an accurate transcript? That court reporters would be the transcripts produced would be more accurate if they were made simultaneously rather than after the fact using an electronic recording?
I'm not aware of any lobbying efforts, but I am aware of some issues that came up during COVID when we started having a lot of remote hearings, and in the era of you're on mute and turn your camera on or whatever else, we were seeing there was an era for that time. It's been about 2 years, right? 2020 to 2021, 22-ish, where you'd get transcripts with a lot of inaudibles, and our Court of Appeals actually they addressed it in an opinion, and they said, okay, court reporters, you need to listen a little more carefully, because we listened to the recording and we could hear a lot more than your inaudibles might let on.
Oh, interesting.
All of this was, and they were encouraging parties mostly, look, if you're going to have a remote hearing, make sure you make a record. If somebody's in the background and speaking, it was a criminal case, and I believe the defendant was in jail during the hearing, and they had audio equipment set up, but as you might imagine, it was not the finest quality. So the court was mostly urging parties and courts to make sure that there's a good record made. But that's more of a hiccup of an unexpected event and adapting to a new technology, I think. I'm not aware of any lobbying efforts. I could be totally out of touch on this, but I'm not aware of any lobbying efforts to either the legislature or to the court saying, yeah, we need more live court reporters. Maybe because they're doing plenty of business just sitting at home in their pajamas typing up transcripts, right? Maybe they like working from home as much as a lot of other people, and they're not eager to,
who knows, right?
To put on a suit and break out the little typewriter thing.
Right. Well, one other question on this topic of court reporters and electronic transcripts. Do you know, in California, we have a statutory presumption that a court reporter produced by a certified shorthand reporter is presumed to be an accurate representation of what occurred at the proceedings being transcribed. Do you know if there is a similar presumption under Utah law that the transcripts produced by the court reporter who is listening to the electronic recording after the fact is deemed to be an accurate representation of the proceedings?
I am not, but I do need to say two quick things. One is what I said applies to state court. Last time I was in federal court, and it was just it was a motion to dismiss hearing, and there was a court reporter there, and she was stopping the attorneys when they spoke too fast and asking them to slow down, that sort of thing. So what I said does not apply to the Utah federal courts. That's just my state court experience. Mm-hmm. But I'm not aware of a presumption, but I do know that if you every now and then you'll run across something in a transcript that the trial attorneys just know was wrong, maybe they just misheard a word, or maybe they omitted something that should have gotten on there. We have a rule of appellate procedure where you can move the appellate court for a remand for the trial court to fix something like that.
I see.
So that presumption, if there is such a presumption, it's rebuttable.
Okay, let's talk about stare decisis. In California, there is no horizontal stare decisis, as our listeners know by now. In the federal system, once a court of appeal has made its holding, that's the holding. But in California, the first district, for example, might have a holding right on point, and then the second district can say nuts to that and just ignore it. For that matter, even the first district can say nuts to its own holdings. And when arguing in the California Court of Appeal, a blog post has just as much precedential value as the opinion that the panel handed down yesterday, which is to say none. How does it work in the Utah system? Is there horizontal stare decisis? You only have one district court of appeal, correct?
Yes, we only have one intermediate court of appeals, the Utah Court of Appeals. And they are bound by each other's decisions. We have 7 judges. They sit in panels of 3. But we also have a case from the Utah Supreme Court saying they can overrule themselves. Like usually that's the job of the Supreme Court, or at least the higher court of appeal, right? To, if you have more than one layer of review, as some states maybe do, to correct the lower courts and say, oh gosh, there's this tension in your decisions, or you don't have the power to overrule your decisions. That's our job. No, our state Supreme Court has said, no, as long as you use the factors for deciding whether or not to overturn a case. So your standard, was this precedent right to begin with? Is it working well? Has there been an intermediate change in some circumstance that justifies going in a different direction now? That sort of thing. They can reconsider their own precedent, but they just have to go through the process that's set out to do that. They can't just do it because they feel like it.
They can't just ignore it.
They have to justify it. Yeah, exactly.
They can't ignore it. So they have to acknowledge the prior precedent, and then rehearse the factors and show that those factors are met.
Yes, and as a matter of practice, I think they're fairly loath to revisit their precedent. They're mostly inclined to stick by it. But if you can make a good case, sometimes it's been a while and it's time to overturn something, and you can do that without having to resort to the Utah Supreme Court. Of course, that increases the odds. If our Court of Appeals were to overturn its own precedent, I think that would really increase the odds of getting cert review in the Utah Supreme Court, because then they would think, well, maybe it's our turn to chime in on this.
The other hobby horse that I like to get on is about unpublished opinions and the rule that we have in California that you may not, under any circumstances, cite to an unpublished opinion. Technically not even to show a split of authority, which is one of the few grounds that you can get the Supreme Court to grant review, even though the Supreme Court routinely looks the other way at that regular violation of the no citation rule. Do you have unpublished opinions in Utah, and are you allowed to cite them at least as persuasive authority?
We did, and yes. So between 1997 and 2010, we had unpublished opinions that they weren't sent to Westlaw, but you could get them. We have a public citation format, or a public domain format in Utah. They'd post them on the website, and you could cite to them. You just had to include the public domain website and then a big U at the end of it, so they would know it was unpublished. But there were no rules saying that you couldn't talk about it. What we have now, they got rid of those, probably because everybody was just citing them as if they were published opinions. So maybe the court thought it's not worth our time to even designate something as unpublished if it's just going to be treated in the same way.
So now they just publish everything?
Yeah, everything's published, with the exception of they have a procedure that they can follow to resolve cases without issuing an opinion. If it's just based on clearly established law, then they can put it on this track where they're going to resolve it by an order. Now, I think it's technically possible. I'm not aware of a rule saying you can't cite to those orders. I don't know why exactly you would, but you'd also have to track them down. They're not going to be anywhere but available from the court itself. But so we do have kind of these shadow opinions, but they're only like 1 to 5 pages, and they're usually just based on such clearly established law.
Yeah,
there wouldn't be any reason to cite them anyway.
Yeah, so those orders on the so-called shadow docket, they're technically not considered published?
Yeah,
So they
yeah,
are.
they're not published anywhere. They're just kind of orders resolving the case that go out to the parties involved, and that's all.
Yeah. Now, I wonder how much it still makes sense to continue using the term published and unpublished, right? Because we all know that the word
They're all
means
there.
that they used to get put into the reporter system, but no
Yeah.
one looks up cases in books anymore, so no one cares if they are literally published or unpublished. They're all on Case Text, our sponsor, or if you're with one of the old guys, Westlaw or Lexis. They're all online, so published or unpublished is just a designation at the top of the opinion, or a U in parenthesis at the end of Utah opinions. So I don't know if it makes sense. It's just kind of a fig leaf that we're using in some jurisdictions to say, don't put this back in my face again.
Yeah, I suppose it would serve some value if I were on an appellate court with a very high volume caseload and without horizontal stare decisis. It would be quite a chore to have to justify one's departure, or if you did have it, it'd be hard to justify your departure from two or three other courts kind of approaches within your own jurisdiction. And with a high volume of cases, it would be very tempting just to say, well, we're just going to limit this to its facts. Don't hold us to it in the future. But I don't think that serves the law very well. I don't think it serves practitioners very well. And perhaps the solution there is just more funding and more courts so they have the time to make sure that it all fits together.
Yeah. Well, here's what I think could be a quick question. Evidentiary rulings. Do you know in Utah or in California, evidentiary rulings are reviewed on appeal under the abuse of discretion standard. So sometimes grates on me because hearsay is black or white. You know, it either is hearsay or not hearsay. It's not a discretionary call, but that's how it's treated. In Utah, are evidentiary rulings reviewed for abuse of discretion or on a de novo basis?
They are reviewed for abuse of discretion, but the court is always careful to say, but the interpretation of the rule is something it's a legal question that we review for correctness or de novo, whatever you want to call it.
Got it.
And I think the reason that they generally keep the discretionary language is because you have Rule 403 that says even if something's relevant, a trial judge can still kick it out for various reasons. And they want to ensure that courts understand that they have that kind of discretion still. They don't have discretion to misunderstand the law, as it were, but whether evidence ultimately comes in will often depend on 403 questions. So I think that's why that language persists and makes sense, though, like you say, for your ordinary like hearsay question or whatever else, it doesn't seem like it should have any discretion involved.
Yeah.
I think that's why.
Jeff?
I was just going to add before we move the away from the area of comparing states to states in terms of procedure, I just want to congratulate you. I read in prepping for today's interview that Utah either has passed or is on the precipice of passing a new, more robust anti-SLAPP law. Anti-SLAPP's a big part of my practice, and I think ultimately it really helps lawyers kind of curb abuses in the profession. And I just want to congratulate your state for joining the rest of us like California and having a robust anti-SLAPP law.
Well, the state of Utah couldn't be here today to accept this award, so I will accept it on
Nicely
behalf
done.
of our fair state. Yes. She
Okay.
wishes she could be here, but
I do note that a big part of my appellate practice is dealing with appeals of an anti-SLAPP decision. There's a right of immediate appeal. You don't have to wait till the end of the case. I don't know if Utah's law has a similar right of immediate appeal, but be prepared as an appellate practitioner to deal with anti-SLAPP appeals coming your way.
yeah, we do see those from time to time. I think those kinds of cases would be more likely to get interlock, discretionary review.
Yeah.
I'm aware of a right of immediate review. It may be. I'd have to look at those statutes here.
Okay, a couple more quick questions before we move on to the lightning round. John, in California, we have a right to get a written opinion on appeal. So even if the Court of Appeal doesn't think much of our appellate arguments, they still have to give us a reasoned opinion affirming the judgment. And I was shocked when Lindsay Lawton, a Florida appellate attorney, told me that Florida doesn't have such a rule, and so as a result, a lot of their affirmances are summary affirmances. Does Utah give appellants a right to a reasoned opinion, even in the case of an affirmance?
No, I don't think it does. And those cases disposed by orders demonstrate that. If I remember, it's been a few years, but I remember reading a Utah Supreme Court case saying that there's no right to that. I have a question for you though, because doesn't the California Supreme Court often issue, maybe it's just they just affirm without opinion?
Well, they will routinely deny review. So you don't have,
that's in their denials.
Yeah, you do not have a right to review. So as a practical matter, your appeal to the Intermediate Court of Appeal is the court of last resort for all intents and purposes, unless you're one of the rare the rare cases that get granted review in the Supreme Court.
Yeah, writing a petition for review to get the California Supreme Court to accept your case is a rare skill in our state, to be able to write such a brief and get the attention of the court.
Well, and you got to be a renegade because you're citing all those unpublished opinions where things have gone different ways, right?
Well, ironically, you can't. This is another one. I mean, don't get Tim started on his ranting, but yeah, you can't really cite to those unpublished decisions.
Right.
Maybe you can advert to them perhaps instead of citing to them.
All right, to close out on our comparative law part of the program, are there any other common traps, unusual civil procedure rules in Utah that you'd like to share with our audience, or bounce against us to see if there's something different about the way we practice, maybe on summary judgment procedure or post-trial procedure?
Yeah, on the post-trial procedure thing, I know that in California that sometimes you have to preserve an issue for appeal, you have to raise it in the post-judgment motion. Is that correct?
Yeah, well, certain issues in state court here in California, you have to, if there are any challenges to the amount of the damages award, if it's too much or too little, you have to raise that in a new trial motion. But otherwise, it's a little bit more lax than the federal rules under 50A and B, which require that any legal issues, judgment as a matter of law issues, be raised in the first instance to the district judge before the jury is charged, and then again after the jury is charged, in order to preserve it for appeal. So the California state system is not that rigorous about how to preserve issues for appeal. It's just the amount of damages is the only one that you really have to raise in a new trial in order to preserve it for appeal.
Yeah, and I guess that makes sense because it doesn't arise until there's a verdict, right? And does that mean it has to be in writing, or can you just say it's too high, Judge, after the verdict comes back?
No, you got to make the notice motion.
Yeah. Well, and that makes sense.
In writing.
It's better to have in writing. And there are times in Utah where I will see, we follow more the federal procedure. They'll raise the objection before the verdict and then after the verdict again in writing. And if there's any question, it's possible that the appellate court might say, well, the raising it in the first instance was enough. You preserved it because the trial court had a chance to address it or whatever else. I just say, keep objecting and don't waive to make sure that the court doesn't get the impression even that you're okay with what happened, right? You don't have to be obstreperous about it. You don't have to be a jerk. Just say, look, I just need to preserve my record here and do that, whether it's in writing or orally. So object more than you think you have to, unless the court's getting really upset. Like sometimes you might have a standing objection to evidence that came in or a witness testifying or something. You don't need to be You don't need to go over the top with that, but err on the side of making your objections known.
That's right. Yeah, Jeff and I did an episode on motions in limine, and sometimes you get those vague orders. It's not quite granted. It's well, we'll see about it when the evidence comes up, and you have to keep objecting until the judge tells you to shut up and sit down.
Well, and something else that we see sometimes too is judges who, for whatever reason, because of the press of the litigation or distraction from other things, will not remember to rule on a given objection. Maybe they'll take a recess and it'll just go away. So I always tell attorneys, get that ruling, whatever it is. I know it's annoying. I know the judge might hem and haw and roll their eyes a little bit at you, but please get that ruling.
Yep, that's another reason to have embedded appellate counsel there, to keep that checklist of all the times that the judge took it under submission.
Oh yeah, and in trial attorneys' defense, they have their attention divided in so many different ways. I mean, I've done trials, and you've got a witness is testifying. You're listening to what opposing counsel is saying. You're trying to decide if there's an objection there. You're looking at how the judge's reaction. You're looking over at the jury's reaction. You're kind of chatting with your paralegal. Like you're trying to keep track of so many things. So yes, embedded appellate counsel can take that off your plate and help keep track of things that otherwise would fall through the cracks that will be very important when they come up on appeal.
All right. Well, that concludes that light lifting. Now Jeff has some heavy work for you.
Yeah, all right. This is the time for our patented copyrighted segment of the show that answers the most pressing questions that vex appellate nerds around the world, our dreaded lightning round. And you've listened to the podcast, so Tim is going to be ruthless in enforcing short responses to these important questions. All right, here we go. Are you ready, sir?
Ready or not? Here we go.
Font preference, Century Schoolbook, Garamond, or something else?
Century Schoolbook.
Correct answer.
With a period, 2 spaces, or 1 after a period?
1. This is not 1984. We have word processors.
Very good. Pled or pleaded? PLED or PLEADED when you're writing it out?
I will respond with my own question. Read or readed?
Nicely done.
I say pled. Analogizing to read.
Yeah. That is correct. In the major argument headings of your brief, with the Roman numerals, etc., do you use all caps, initial caps, or sentences?
Sentences, always. It's so much easier to read, and it's not a written form of shouting, and it's not a newspaper article.
And I like your lack of equivocation, John.
Yeah, it's
I have strong opinions. You're going to hear about it.
The use of the parenthetical cleaned up by lawyers, not judges, but by lawyers in briefs, appellate briefs.
Absolutely. I use it all the time. I think it's great.
You know, I have yet to read a California published decision where they've used that. I've seen some unpublished decisions, but in California, state courts haven't really adopted it yet in published opinions.
Our Court of Appeals first used cleaned up I think about 4 years ago. And that's when I learned about it, and I hopped on and learned how it came from appellate Twitter and read the law review articles on it and everything else. And I thought, this is a great idea. Why haven't we been doing this more often? And there was actually a split of authority on our Court of Appeals. Some judges would use cleaned up, and others would use quotation simplified. And that persisted for a little while until ultimately, I think our state Supreme Court started using cleaned up, and everybody just said, okay, I guess this is okay now. So I took my cue from our courts, but I like it. I think it's great. Yeah. When appropriate, right? You don't want to misuse it, because there are ways to misuse it and to be deceptive, but to avoid having like 14 nested quotations and a whole bunch of unnecessary citations. I think it's great. It's what the court said. So just say what the court said and leave brackets and the quotes out if you're not making any changes.
Yeah, I'm all in favor of anything you can do to reduce speed bumps for the eyeballs. And so I'm a big fan of cleaned up. All right. When writing out the phrase attorney's fees, is it attorney apostrophe S attorney's fees, or attorney's S apostrophe attorney's fees?
Doesn't it depend on whether there's more than one attorney?
Yeah, I suppose so.
If there's one attorney, it's apostrophe S. If there are multiple attorneys, then it's S apostrophe.
Let me ask you, my preventative answer to that is just attorney fees with no possessive. Is that the chicken's way out?
Yes, it is, Tim. You're a coward.
I'm a coward.
All right. Final question. By the way, everyone on my staff knows that I don't know how to use commas or dashes either appropriately, so I just don't use them. So I do not have a strong feeling about this answer. Dashes. Do you use an M dash, a long dash without spaces on either side, or an N dash, a shorter dash flanked by spaces?
Oh, M dash with no spaces. It is so much easier on the eyes. I saw some crazy person the other day who used an N dash with a space on only one side. And it blew my mind. I couldn't believe somebody was doing that and walking around among us.
You think we appellate attorneys are calm, cool, and collected, but you use a dash the wrong way, and it'll just set us off.
Oh yeah, the inappropriate possessive. We're just walking around angry all day. It's like the Hulk, right? Like our secret is we're always angry.
Well, in case
grammatical and punctuational mistakes.
All right. In case Jeff was going to skip it, I had to ask you about this possessives question. How do you make the word Congress possessive? Is it Congress apostrophe, or is it Congress apostrophe S?
As I understand it, there are two exceptions to the general rule of usage that way. I use Congress just plain apostrophe. Jesus is the other example that I've seen, these historical examples that's just the way that we do it. I don't think it's consistent, but I think it is an exception to the general rule. And I'm trying to remember, it might have been a Brian Garner tweet or something like that where he addressed it.
I bit my tongue at pled, and I bit my tongue at at cleaned up. But what sound does an apostrophe make? It doesn't make any noise. It's a silent punctuation.
No, it absolutely makes a sound. Every time you add you're adding some layer of meaning. So I had a family across the street when I was growing up. It was the Briggs family, Briggs. And if something belonged to if I was talking about more than one Briggs, it would be the Briggses with ES on the end.
Yeah.
And if something belonged to multiple members of the Briggs family, it would be the Briggses.
No.
Yes, absolutely.
You know what? Okay, we're gonna have to call it at that.
Yeah. All right.
One area.
So this is interesting. I've always thought about it's kind of like you think about something that's written, but you don't think about saying it out loud. But I've always kind of read that out loud in my head as the apostrophe having an is sound.
The Briggses is.
Yes.
I think to say it is to refute it.
I want to follow up on this now. I've got to research this.
Time out, you two. All right, time out.
All right.
You have bogged down my lightning. You bogged down my lightning round in minutia. Normally, I tell guests that you survived the dreaded lightning round, but I have to tell you, you conquered our lightning round. So congratulations, sir.
Over protest.
That was a mic drop for those who couldn't see that.
I'd like to register my protest, Jeff.
Yeah.
Your disagreement is noted.
Right. All right.
We'll still reflect. Say anyway.
All right. I think we're going to wrap up this episode, Jeff, unless you have anything remaining.
Nope.
Okay, then we're going to once again thank our sponsor, Casetext, for sponsoring the podcast. Each week, when we include links to the cases we discuss, we use we use Casetext, and listeners of the podcast can receive a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
And if you have suggestions for future episodes, or you have an example of an apostrophe that makes a sound, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay groundwork for an appeal when preparing for trial.
Thanks again, John Nielsen, for being with us.
Oh, it's been a lot of fun. Thanks for having me.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.